is a minor subdivision. There are no variances. There was no notice required. No notice. So, and you are.
I'm his sister, and I have authority to speak for him as a family member.
Are you an owner?
No, I'm not. I'm his sister.
Is he incapable or out of the country or?
No, but Mr. Stockton said it was okay.
He gets his law license, you let him know. You got power of
I'm
attorney?
sorry, I have no idea what I'm doing.
We're not trying to give you a hard time.
No, I know.
I'm just trying to identify your Mr. Amodio's sister.
Yes, and I have a letter right here. But I think you might have the original already signed.
Is it a power of attorney?
Or your first secretary
Can I see that?
that I saw
Can I see
back in
that,
the
please?
fall.
Wow.
Can I see that, please?
Yes, it's not signed.
Well, this is a very minor application. To the extent that testimony is even required, perhaps not. You have everything before you, you have review letters. I'm not too sure that there's really the need for testimony. I'll leave that up to your board, the professionals, whatever. If there are questions, it's, you know, I mean, for example, if the board says, will you do this, will you do that? You have authority to bind your daughter?
Yes.
How do we know that? I'm asking the question.
The first secretary that you had, I gave, and I was told everything was complete. I even called before May 1st to ask what the service meant, and it meant if I needed anybody within the 200 feet, I would have to send letters, and they said, no, I don't need that. So I said, are you sure I have everything I need? And they said, it is a simple thing. You don't even need Mr. Stockton.
Okay, I don't know. So let's go back to one thing first. You are Cheryl Wilson.
Yes, I'm his sister.
We have a letter signed. It's notarized. Okay, we have the letter from...
It's a funny thing, my father was an architect, my brother's in construction, and he wouldn't do this. He had me do it.
You drew the short straw?
I have no idea what I'm doing, to be honest with you.
Sorry, what is the letter say?
And Mr. Stockton and my father.
Okay, move forward.
Okay.
Sam, you want to explain this?
Oh, I thought I had to.
Do you want to? You can. You're not saying anything. So it's
Oh, I'm sorry. My
This is
brother
getting,
had
it's
2
awkward and
lots.
getting confusing.
I'm
Let's-
sorry.
Let's do a simple thing. Come on, please raise your right hand. Swear testimony about to give the board the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
And your name again,
Cheryl Wilson. I'm Frank Amodio's sister.
and your address.
My address is 21 Swan Avenue, Locust.
So, the applicant is seeking approval to subdivide an existing lot, which contains an area of about 26,894 square feet into 2 lots, lot 13.01 and 15.01, a single-family residential homes. The proposed lot 13.01 will contain approximately 10,280 square feet, and the proposed lot 15.01 will contain 16,664 square feet. The applicant is proposing to remove one metal garage and reduce the surface area of the existing driveway. So there are existing non-conformities. There's no problem with, there are no variances created by this application. And one is a principal side yard setback. You require a minimum side yard setback of 12 feet, while the existing house maintains a setback of 9.1 feet. This is again existing non-conformity. It's not affected by the proposed subdivision. Accessory side yard setback requires a minimum side yard setback of 12 feet. For the existing detached garage, maintains a setback of 5.4 feet. Again, this is an existing non-conformity. It's not affected by the subdivision. So the applicant is proposing a side entry garage on proposed lot 13.01. What I'm asking is that this shall be a condition of approval. Are you okay with that?
Yes.
Okay. We had commented about, street trees required at 30 feet on center. They're proposing red maple. We don't have a problem unless the board engineer has additional landscaping comments. Now, another thing is that the ordinance requires sidewalk construction along existing street frontages. So you're required to either provide sidewalk or justify a waiver to the board as to why you don't require sidewalk. And if the board chooses to waive it, then you need to do a contribution in lieu to the Township Sidewalk Trust Fund.
Are there sidewalks out there?
Part of the sidewalk?
No.
Yeah,
There's no sidewalks.
No, there aren't. So
There aren't any sidewalks.
there aren't any, and if the board is amenable, then, waiver needs to be
And
granted.
with a minor subdivision, it's a couple $100.
Yeah, like 500 for 2 lots, right? 250,
Yes, correct.
it would be
On
500.
Osborne Avenue, I looked at this, there's a number of trees, large trees, some are two together. I don't think you even have to add any more street trees.
I mean, they're proposing, I'm
Very large.
okay with it, I don't have a problem with that. What I would, there are some minor changes that Mr. Stockton needs to do, like, for example, there's an issue with the tax map and whatever discrepancy, which I wrote in my review letter. It's really minor, he will take care of that. But you need to know that all the proposed block and lot numbers must be approved by the tax assessor. And we also require that utilities have to be installed underground for the new house.
I do that then,
Whoever,
or the seller,
the
the buyer.
the buyers will have to do it,
buyer
whoever
does
builds the
that,
house. Yeah. And then we noticed it's just property.
Let's cut through this, if we can. You're going to agree to the report, right? I mean, is there anything, have you seen the report from the professionals?
No.
Oh, that's hard,
Oh, it was sent.
that's hard to agree to something you haven't seen.
It was sent to you.
What
It was sent to
date?
Mr.
We had another problem when I had to come. What date was it sent?
It was sent last week.
I didn't see that.
Did it go to
It
you
went
or
to
Mr. Amodio?
No,
It went to
it's-
Mr. Amodio,
I
same
go
address
to
we have sent
South
it
Amodio.
It was the same letter, same address that the fee letter and everything else had been sent to. The hearing letter was sent there.
Well, last time I came to you, you had the stuff in your hand to do it.
We're trying to help.
No, I know.
We're trying to help, it's just that,
Whatever you
there's a-
tell me to do is
Yeah.
fine.
right, we're trying to help. So-
Whatever you tell me
So
to
let's
do.
go through the list of things that, that you'd be agreeing to basically tonight.
Okay.
So there's reports from both professionals. You're going through the planner's report. One of the conditions is the subdivision plan shows that your neighbor's fence encroaches on this property. And it says it should be removed. I'm looking at it, it's a very minor fence encroachment.
The fence, yes.
That typically you wouldn't bother your neighbor about it. It's not going to affect the subdivision. I would just suggest to the board that not be a requirement, because,
We are gonna have them,
oh, then you're
so
going to take it down, okay,
make them move it.
okay.
Move it over to their property.
I'm going with the surveyors, yes.
Yeah, you can
We're
take it,
gonna make
okay.
them move it.
So
If you build the new home on the new lot, it's
Yes.
going to require a contribution to the township's affordable housing trust fund.
It may not, it's just if it's one house, I think.
It's only one?
Exempt,
It's
yeah.
gonna be one home, sir.
I think.
You think so? One?
Yes, I think.
We don't have enough.
not
Yeah.
putting 2 homes up.
If it's 2
It's
homes
only
or
on the
more.
second home that it requires?
If it's more than, if 2 homes or more is when it's required.
So
If
it's exempt on one?
On,
Okay.
yeah. I do.
So no contribution?
Correct.
Yeah, because I wrote there, the applicant is creating one lot that was exempt from this requirement. So the only contribution would be sidewalk, and then the metal garage must be removed prior to the filing of the subdivision deeds.
Okay.
So that,
And why is that? That has a dirt foundation.
because that's what your plan is saying, that you're planning to remove it. So we're saying remove it before the subdivision deed.
And the sidewalk contribution is how much?
$500.
Okay, and why is that when none of the blocks where we all live, no one has a sidewalk on either side? No one.
Correct, but you're applying for a minor subdivision, so if your neighbors were to come and apply for a minor subdivision, they would also either be required to put a sidewalk or do an in lieu contribution.
Okay.
Stan, on the plan, where's that garage
The
building?
metal garage is on the new proposed, where the existing lot is.
Behind the regular.
It's behind the masonry garage, it's almost,
It's like a tin shed.
yes, but it's abutting, garage to be removed. We require that you remove it before filing the subdivision.
Okay.
Okay?
So that gets moved, then I come back?
No, we're trying to take care of everything here tonight.
Oh,
so you
okay.
don't have to-
I just have to get that garage out of there.
Yeah, but we'll explain to you what the next
Okay, I'm
process.
sorry. How we,
Sorry, sir.
Now, are you going through your letter saying, for instance, in building design, that they need to know, she's agreeing about the no side entry garage?
Oh,
I'm
yeah,
sorry,
no, she
yes,
said,
the side entry.
yes, she said yes to that.
yes, I'm taking the
Okay.
garage down.
No, you're saying that
No,
the applicant, this shows a side entry garage. So when the house comes, there'll be a side entry garage. You're agreeing to that, correct?
I have to put a side entry on the old garage?
No.
Your new garage over here, this is your new house. You're proposing a side entry garage. So you're agreeing that that's how it, when eventually you come, that's how it's going to be, correct?
Okay, but I don't, I'm selling that, so they do that.
They're gonna have,
Their
Who's
garage
ever-
is gonna have to be
it's
on
gonna
the
have
right.
to be a side entry garage.
Okay,
Okay.
thank you, I get that.
And proposed block and lot numbers must be approved by the tax assessor. So you need to get that from the tax assessor if he's okay with these block and lot numbers.
Okay,
The metal garage must be removed prior to the filing of the subdivision deeds of flat. And then you said that you'll get the neighbor to remove the fence.
thanks.
So that's it from my end.
Thank you.
Rob, you got anything?
I do.
Good stuff.
I'm sorry.
Usually it's just document with agreement for each item, so to make sure everything's
She
addressed.
knows, right?
So starting on page 1, B2, because B1's already been addressed with the sidewalk. B2 has a few items in it. One, you will request a road opening permit through the township for the work within the township's right of way. That's a standard requirement, so I'm just acknowledging that you're going to have to request a road opening permit from the township.
Okay.
In addition, there are many plan revisions that have to be made, as we typically request. Connection details shall be provided for utilities as appropriate. Pavement restoration limits, information has to be provided. And we, as we always do, request one surface pavement repair that will encompass all the utility connections. So we don't have numerous trenches within the roadway. Do you agree with all that?
Yes, I don't understand it, I agree. I should call a lawyer, I think.
But you can do, because you don't have this letter in front of you, right?
I do right now,
Oh,
yes, sir.
okay.
So,
Rob's comments are referencing to Mr. Stockton's signing plan.
So he'll help me.
so Mr. Stockton typically adds this information. This is common comments on, when we have, Mr. Stockton has a plan in front of us, and he agrees to add this additional detailed information on his plans.
Okay.
And I just, the board secretary just informed me that they were emailed to Mr. Stockton as well.
Okay.
So,
He'll know what he
He'll
has
know
to
what
do.
to do. Okay. He told me to call him. Okay.
And he can always call either Rob or Sam.
So on page 2B3, again, revisions to the pavement repair detail
Yes.
we're requesting. We're asking on 4, we're asking for a note that should there be any damages caused by this construction to the pavement, that the applicant, or in this case, I guess the builder, would make those repairs.
Okay.
5, the applicant proposes a new driveway apron. However, therefore, a detail of that apron should be shown on the plans. In addition, if it's a concrete apron as shown, we request a depressed curbing along the front of that, which is typical.
Okay.
C1 is essentially asking what talks about parking, the requirements for parking. Will you have a garage on this house, and if so, would it be 1 car, 2 car?
I don't know. We're just going to sell the property, whatever the builder decides.
Because
To build.
the plans show that there is a garage. They show the driveway going to the garage. There's a side garage.
But we subdivided this differently.
What do you mean?
This property was all connected between Demerit and Osborne, and on the corner was a house of Osborne and Demerit. And we combined the 2 properties to sell the property. And the lady's fence on the right is 5 feet on our width on Osborne. This property has nothing except that shed behind the garage. And the way the surveyor was able to get the footage, he angled it. So the garage stays on my brother's driveway on Demerit Avenue. Behind that's a piece of land, a little piece of land, and that shed. Mr. Stockton didn't think the shed had to come down because it was metal and it was on dirt.
he actually said garage to be removed, so he made a note there.
Then he revamped it. And he resurveyed this to combine the those properties on Osborne.
Was this property previously subdivided to create the lot that exists now?
No, it's never been subdivided. It was 2 little pieces that they put together, Mr. Stockton,
I'm not sure what that means.
to build 1 home, to be sold for 1 home
Where are the 2 little pieces from?
on Osborne, number
There's a subdivision being requested.
Yes.
And
mine.
on the lot 13.01, I'm proposing as well. I think that's what she said.
Yeah, that's what I think she's saying. What it is it's an L-shaped property, and they're subdividing that into 2. One, the proposed 15.01 will front on Demerit Avenue, and the other, which she's talking about, 13.01, will front on Osborne Avenue.
That's what
I'm
we
sorry, are we
sold.
starting with one L-shaped lot? Or
Yeah.
the way
Yeah.
it's-
It's
But the way
L,
this
but
way
there's
this
a
is-
corner house.
No, this is the corner house.
No, no,
See the corner house?
I understand the corner house. I'm saying that the current L-shaped lot, I'm looking at,
Yes.
throughout this year letter, right, again, it seeks to combine lots 13, 14, 15.
Yes,
And then
there's 3.
this 3, combine them into 1, and then subdivide the new 1, which is now L-shaped, into 2,
Yes.
correct?
Yes, sir.
16 acres.
So this one's hard to read.
It's this.
It's also nice pivot for this, what this dot saying.
On your plan, there's Mr. Stockton's plan, it talks about eliminating property. So are there 2 tax lots out there now?
We actually had a home on Demerit with a tax, and then we had 2 little pieces that a year or 2 ago, the township started sending me one for those 2 on Osborne.
They combine them.
They combined them, the township did that before I even started this. Instead of having 3 pieces of paper, I went over with 2.
So could you on the plan show the board where the existing lots are? Can you,
I've spoken to the tax assessor, I made a comment about that the zoning table and the general note number 2 notes that is the owner of block 787, block 10. We believe that is in reference to the old block number for the site and was merged with lots 13 to 15. And so originally it was lots 13, 14 and 15. In 2018, lots 13 and 14 were merged. So we have lots, so 13 and 14 is one lot and then there's lot 15. But the tax map, there's an error there, it's not been rectified.
so there's 2 horizontal lines that are rather difficult to, you can see them in the spots where it says eliminate property. But then as you carry them forward, they kind of get lost in other lines. So right now on Osborne, are there, at one point on Osborne, there were 2
Yes, sir.
tax lots on Osborne
Yes, sir.
that went from Osborne to the rear,
Of the side of the garage.
including the masonry, like one
It was
basically included.
partially, yes,
Yeah,
sir.
so one included the masonry garage.
Yes.
And one
And
would
he's-
include the area where the metal shed is.
Yes, and he subdivided it for us. And got to keep the cement garage with the Denver Avenue property. And my brother doesn't understand, but he agrees to if he has to take down that metal shed with the dirt base
Okay.
that stores a lawnmower and wood.
I'm going to try, and I probably shouldn't make too many assumptions here. I think what the tax office did was to combine the 2 lots on Osborne, just saying they neither one conformed, so they merged them and sent out one tax bill
Yes,
for the Osborne on back to wherever the property is in the back.
yes,
And then that made then the existing masonry garage on a different tax lot than the existing house. And because of all of that, you could make the argument that all of this property is, this may make it simpler, all of it is just one lot. Forget all the existing lot lines, tax bills, and everything else. It's just an L-shaped piece of property with stuff on it, you know?
yes.
And if you take away some of the lines that are there now, you know, through the tax line, they're just clutter on this plan. I mean, you know,
It's an
they're,
empty lot.
just call it, it's a lot. It's an L-shaped lot. So, you know, I think that eliminates some of the confusion as to what's out there now. I mean,
Yes,
right. I mean, how it got to be where it is now, I don't really know.
yes.
You know, but it's forget the lot lines, forget the tax bills for right now. Just call it a big piece of property, you know, and they can break it down into 2 lots, which could be one.
That's pretty
If
much
he
it.
would have given rid of the cement garage, the township told me I could have had 2 narrow lots. But we didn't do that with the surveyor. We're just gonna sell it as one. But the neighbor has to move her fence.
I have a quick question for you. Mr. Stockton, was he unavailable to come tonight, or did he feel he didn't need to come?
He felt like he didn't need to come, he has heart issues, and my brother spoke to him a week or so ago when he went and made a payment, and he said because it was simple and minor, and that everything was marked, he didn't feel that, and he didn't feel originally, because it was going to be simple, that we did not really need a lawyer.
But the surveyor would have been nice. This is Mr. Stockton Senior.
Senior.
Yeah, I know him personally, he's been ill.
Yeah,
been
that he
ill.
has, yeah.
I've been there many times,
And it's your brother, correct, that is the owner?
yes, and his
And he
son
was-
has been out there a few times in speaking with my brother.
Okay, and your brother couldn't come either tonight?
He just gave me the right to come because he spoke to Mr. Stockton a week or so ago.
I guess my feeling here is, if you don't mind me voicing it, I'm just concerned for you because this seems to be a little bit more complicated than you expected. And I'm just a little uncomfortable making assumptions here. So, I don't know how, Rob, I don't know.
I tend to agree with you because we're talking about items that she's not familiar with. So, and she's agreeing, which
It's not fair to her.
is most likely okay, but she doesn't really know.
But I've
Right?
been here to Mr. Stockton like 5 times.
But he's not the legal person, Mr. Stockton.
No, but he did the best he could.
Yeah,
to
but we're
give
not
us-
saying he didn't do the best he could.
No, to
We're
give
just,
us, to keep as much property as possible.
my concerns are for you here tonight.
Well, it is what it is, we have no choice. We needed X amount of land in the middle, so we gave away a little more of the width of Osborne to get the most. We could have kept 9 or 12 feet as an easement, but that was kind of not like really worth it. We are just looking to subdivide it to sell it. It is what it is. He's
You're
willing to
selling-
knock the shed down. Mr. Stockton was able to save the garage. He's going to have 20-some feet from the side of the garage. He's going to have behind the garage. So it's just a lot now with a few trees on it, is all it is.
Yeah, but sometimes it's not quite that simple.
What,
It's not, and
Well, we were told, and I've been speaking with you and your first secretary and the nice fellow that worked there. You know, Mr. Stockton seems like it's a simple thing that we have the footage, what we needed.
when you're, wait, a question. When you're done with this, you're going to wind up hopefully with 2 lots.
No, just one.
No.
Oh, he's one on Osborne and one on Demerit with the house he lives in. Yes, the one on Osborne is a little wider than we needed. He's gonna sell that piece.
First, before you can sell anything, you must get this subdivision
Yes.
accomplished. And that's what we're trying to help you with.
Yes,
And we're trying to understand. I see your lot, whatever it is, 1301 is the one you're looking to cut off and sell, or would like to sell. The other lot, 1501, is going to remain, and your brother lives there.
on Demerit Avenue, around the corner.
Yes.
Completely
it's on
around the
Denver.
block.
It's on Denver, yes. And Mr. Stockton has drawn this up, so your brother's house remains,
Yes, and the garage.
and the existing masonry garage.
Yes, sir.
The metal garage, for some reason,
Is straight behind it.
I know, I see it, it's just gonna go away.
We'll knock that down, yes, sir. He angled the property the best he could to get the footage that the township required.
And the lots conform, Sam?
yes, the lots conform, there are no variances.
Is there any way you can write a resolution off of this?
I guess,
Or do we I want to get Mr. Stockton in here with that.
Well, I think that frankly, from a legal point of view, more importantly than Mr. Stockton is Mr. Amodio, because he's the one who's actually going to say yes or no to these things and be bound by these things. And whether or not Mr. Stockton needs to testify, I think is, to me, a lesser issue. It may be more important to Rob to make sure that Rob goes through and, that Mr. Stockton understands what he's agreeing
I
to.
have a question, maybe to simplify this. You're proposing to subdivide only and then sell.
So,
Someone else will build something on this proposed lot.
exactly. The size to what they're allowed by law.
So Stockton should have their house.
He said we're 25 feet off the front. We have plenty of width. We were trying to save the depth.
So, it sounds like this is really a subdivision with no proposed improvements. The proposed improvements will be by the purchaser of the new lot that gets created, and they would have to comply with the zoning criteria, or if they don't come in front of this board.
That's exactly what he was.
Right, as long as the property's in your
It might
hands,
be in
Cheryl.
my new house.
It's just an empty lot.
It's an empty lot. I mean, somebody might
I
build
agree with
a
Rob
my
saying
new
this.
house and put a basement in.
When somebody else comes along and gives you
They're
what
gonna
you
do what
want.
they're allowed to do. They have to get the stuff. This is what I was told. As long as we're so many feet off the front and we have the width and we had the angle to build a certain size home.
So, but even when there's a subdivision, the board's requiring that it be subdivided, and the condition of approval is meeting your letter.
Right.
Right, with drainage issues. You just had that same issue with Golden Rule about the drainage issues.
Right, the difference is that was proposed improvements, right?
Yes.
And even though it shows proposed improvements, the witness's testimony sounds like they're not proposing to improve it. This is to be future by somebody else.
It's,
That's the
yes.
only reason why it's not.
You're selling a lot. You're
Yes.
not building a house
No.
on spec. and
None of my
looking to sell.
children want it. No. Nobody wants it in the family.
So then all the notes on the proposed lot come off the plan?
It would have to, right? It would have to, that lot should be a blank slate, blank, with no proposed improvements, if this is the direction that we're understanding.
Definitely so.
So if that's the case, then, my letter would get reduced down to really under miscellaneous and the title.
But then how do we advise somebody who's buying that lot, just a simple thing of requirement to put street trees?
Well, there have to be some conditions, right, because it is a subdivision, so street trees are required as the basis of this, as part of the subdivision.
I mean,
So,
those come at the time of, after resolution compliance, when they come to apply for a permit, that's the time we ensure that whether that's taken care of or not,
Apply for a permit for what, to build?
to build a house.
But that wouldn't be them anyway, that would be somebody else.
but it would have to be a condition of.
It's got to be a condition of subdivision,
That's correct.
because otherwise it's going to get lost.
Correct.
The taking down the fence, the encroachments, would have to be a condition of subdivision.
Right, the fence, it looks like the pool decking encroaches as well,
We want to do that.
so that would have to be a condition.
Where's the pool decking?
It's,
That's in the listing.
so it's on lot, it's really where that fence encroachment is.
And the concrete decking goes up to that?
So it shows the fence.
How did they get away with that?
I was suggesting before that's going to be a pretty significant burden for 1.8 feet.
He said 3 something and 5 something on the side. Mr. Stockton,
It was-
son, 3 something and 5 feet.
I mean, is that a condition that the board wants? If I'm looking at this right, it's a concrete area and a fence, that looks like it's going to be 1.8?
1.8 feet, yeah.
Yeah, over. So that means in order to subdivide this property and to perfect this subdivision, that encroachment had to be removed prior to filing the map or the deed, because that's where you are now. That's what the board is saying, that's what Mr. Key's report says. I'm suggesting something different, just leave it alone. And somebody buys that property, buys it with an encroachment on it. And
And
at the
let them
bottom,
handle it at that point,
what's that?
and then let them handle it at the time of purchase.
Because well, you're a real estate, how many times you see something with an encroachment that everybody just goes, you know, because it happened, it existed. The subdivision doesn't, normally we like to clean these things up with subdivision. Right. But,
Well, the
So
only
that-
time it comes into play would be with title and insurance.
That's true.
correct. It's not going to be a title issue, it's not going to be an insurance issue. It's 1.8 foot encroachment that doesn't affect the property. It doesn't affect the use of that proposed lot.
You don't think that's going to affect?
This happens every day, you know, because fences are notoriously off, you know. You don't usually see.
Because I had problems, that's why I'm sitting here, and it's maybe bothering me more than you.
You don't usually see pool decking off, but fences tend to be kind of randomly placed, you know.
You'll see sheds.
Sheds are off all the time, right?
Are you, excuse me, I'm sorry to interrupt, are you seeing only 1 foot 8 inches? Because he's telling me 3 feet on one side and 5 on the other side of the fence.
Well, it's 4 feet 6 inches over on the proposed lot 15.01, and on the 1.8 feet that you're seeing is on the proposed lot 13.01, which has no house. So what you're saying, the 4.6 over is on your brother's lot which has the existing house.
On his side.
Correct.
Oh, I see what you're saying.
Yeah.
The fence along your brother, behind lot 16, towards your brother, that's over by 2.6 at one point and 4.6 at another point. So what I'm
I
saying
wouldn't
is,
really care for one fence, but they're both open.
yeah, but that's existed for a while. Your brother didn't say take it down.
He didn't know, sir, till Mr. Stockton did it.
I'm trying to help,
No.
and you're trying to go the other way. So
No, he didn't know that the people did it, sir.
I got all that. But what I'm saying is, it's not bothering your brother now. If he wants to take down that, right to the neighbor and say, take down your encroachments, get rid of your pools, do whatever, you can do that right now, today, without a subdivision. But to make it a condition of the subdivision approval means all that stuff has to come down prior to the map being filed. And I'm just going to tell you from a practical, matter, writing to your neighbor and saying, get rid of all that stuff before I can perfect my subdivision, is not going to be all that easy to get done.
Depending on the neighbor, which you make.
Yeah, he's not going to go out there and
He's not
start,
gonna be anxious.
he's not going out there
Move his fence.
saw cutting his concrete decking and stuff. I mean, he's just not doing it. Not easily. So if you make it a condition of the subdivision approval, you're creating a problem. And what you're saying is, something different. It's like, now that your brother knows it's encroaching, now it's bothering him, so he'd like to get rid of it. Okay. You can do that. You can do that any time. You can write a letter to your neighbor saying, you're on my property, get off.
And that's why we have lawyers to take care of something like this.
And when somebody comes to me,
I really don't think this board should be actually, this should not be on our purview right now.
No.
I really don't. I haven't seen anything like this in 24 years. I think if we start this now, we're just making a mistake. We used to have a minor subdivision meeting many years ago. That was handling just things like this. It was a backroom thing that we did. But I really don't think this should be carried by this board right
It
now.
was not a back.
Well, it was down here in the corner. It was down in the corner.
It was
Yeah, pretty much.
It was a subcommittee that met and brought, in this case, it would have been her and or her brother and this neighbor over here, this encroachment together.
Together.
And then they had sat down and come up with an agreement that they were both signing off on.
Oh,
No back.
I have the right to agree tonight or disagree. Everybody thinks I should agree and just be done with it so I can move on. Otherwise, I have to delay.
Look, if you're asking me as a lawyer, does a piece of paper that you have give you legal authority to act on your brother's behalf? No. It's not a power of attorney. It was intended to be, it expresses that same intent, but is it?
Does it make anything that we're talking about it like binding on your brother? It doesn't.
Not really. And the other thing is that generally, people have to either come themselves or be represented by counsel, and they don't have to have an attorney. But they have to come themselves. And we make exceptions because sometimes you have somebody who's elderly, unavailable, living overseas, in the service, for whatever reason, age, infirmity, distance, whatever it may be. And we allow other family members to come on their behalf. That has happened on occasion. I don't think, I understand your brother's not here, he doesn't want to come, but can I make a suggestion that perhaps, one, you don't have to do it, I'm saying, but perhaps we just list this someplace early on the agenda coming up, and Mr. Amodio come, or Mr. Stockton come, or they both come, and they then say yes, 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 and then we just finish it, because,
I appreciate it.
okay?
I appreciate it.
I mean, and you can list it, but I'm saying, I don't think it's a lot of time, I think the board just would feel more
No,
comfortable.
I agree with you. That it's not a lot of time, we can squeeze it in here somewhere.
I appreciate it.
And we go from there.
I would
Mr.
feel
Stockton,
more
Mr. Stockton should get the notes here in terms of what our concerns are, et cetera, and clean this up, including, I believe, make that an unapproved lot. It's just 1301 is just going to be,
It is what it
from her
is.
perspective, it's an empty lot I sold.
It is
So,
what it is. Okay, I agree. I appreciate it. You can get me in.
And we're gonna have to, and if we do that, and we're gonna make that property owner, the new purchaser, comply with subdivision requirements, we have to put them on notice. We have to, it's gotta have to be notes on the plan. I presume this is gonna be filed by subdivision deed. It's gonna have to, it's gonna have to put somebody on notice. We don't want somebody closing on the property and then saying, I didn't know that I had to do this or I had to do that.
Do you have a buyer already for the property?
Not really. A couple interested, but we didn't even get a price yet.
Okay.
No.
all right, we're going to, we can't get, because they need time, and Mr. Stockton and your brother need time here, so the closest place we can carry this to is July 10th.
I've been waiting since the fall. That's nothing in June.
Yeah, but it's, you guys can't be ready for the June 5th meeting. We already got a full agenda there.
June 19th.
June 19th is all booked out entirely. So that's what I'm saying, July 10th, we can get you on.
Okay, so read the letter, go to Mr. Stockton, ask him to come with us.
So, why don't you have Mr. Stockton call me? Because he wasn't present during this, he hasn't heard what we've been talking about. Because if you just give him the plan, he's gonna, and our letters, he's gonna make those changes. But it sounds like, again, and I assume your brother would confirm this, that you're proposing to subdivide only. So these plans, by him addressing the letters isn't gonna meet your brother's desires. So if he just gives either Stan or myself a call, put together, we meet, whatever it is, we can, you know, at least advise him of the discussions during this meeting, so he knows how to advise him.
Okay. And then should I plan to come back July 10th or make it settled without coming to the board?
You have to go.
Okay, so you'll put me on the board.
Or your brother.
No, he's coming.
Insist on it.
I'm
And if he comes,
sorry.
you don't have to come.
I'm not coming, I'm sorry. I know nothing. They told me I didn't need a lawyer.
I didn't, no, you don't.
No, but I feel bad holding you people up. I
No,
really
that's
do.
fine.
No, that's okay.
It's, you
But
don't.
we're also doing this for your protection too.
No, I understand that. No, I understand that.
Yeah.
Okay, and if Mr. Stockton won't come, maybe his son will.
Just ask, for now, just ask him to call us and we'll talk with him.
We need an extension of time through July 10th
Okay,
for the board to make that acceptable.
okay. I will call him tomorrow.
And can I suggest that perhaps your brother, you know, come? Because,
I'm not going to.
well,
Howie, I'm sorry.
come, have your brother come. And if Mr. Stockton's able to come, fine.
Okay.
But, you know, if he can clear everything up before that meeting, maybe he doesn't have to come.
Now, if it is a minor thing and it does work out, do you suggest asking them to move the fence or just let it go? Does it have to
I can't
be
give you
done?
advice.
Does it have to be done before anything is settled, that he moves the fence? Because I was told to wait about that.
Look, if you want to put down, if you want to say that those are going to remain, then they remain. And then the
But if
approval
we
would
want
be,
them moved,
then that would be a condition of the subdivision approval.
and that would take.
But it's a
longer.
condition you're putting on yourself now.
Yes.
Right? It's
We're
not-
taking on-
If the fence is bothering you or bothering your brother, you can go today, right, and
We
call
were
your neighbor or
told,
call a lawyer or whatever and say you need to do this. If you make it a condition of the subdivision, if it's actually not bothering you, or not bothering him, and you make it a condition, you're putting a condition on yourself that you will then have to go and call your neighbor and go through all the stuff. If you
And-
called me and told me you did tear up concrete out of my yard, I mean, I'd say call a lawyer and make me do it.
Because what's gonna happen is you won't be able to sell that lot because of the problem.
till it's all fixed.
So it's all fixed if you insist on it.
Okay,
I insist on
okay.
it. But anyway, we need, well, first we need an extension of time.
I'll
Did
call
your
tomorrow.
vote? No, we need an extension of time right now.
Till July 10th.
Exactly.
Okay.
You're going to agree to is we're going
Yes.
to extend the decision.
To come July 10th.
Is extended to July 10th.
Yes, sir. I agree.
Oh, yeah, it's fine.
Is it fine?
To the extent that she was authority. Great.
Otherwise, we dismiss it without prejudice and come back.
Yes, it's extended.
Yes, okay.
Okay, thank you, am I dismissed?
You're free to go.
Thank you.
Thank you. So, the next time,
Call me.
the next time, so
You have access to your
My son and
I'm
I
going
was
to
busy
leave.
doing, I'm
And
very
I'm
busy.
going to buy alcohol.
post this video on.
All right, motion to adjourn. All in favor?
I was told it was.
See everybody. Thank you.
A couple of days, check that.
Thank you.
Hey, Howard.
No, I got that.
You know,
High school.
what you do? That's what I was at the party and I'm going to meet the place. I live next door to you.
No, I could be.
I went to,
So